that introduction. I think anyone who comes into the international community as a defense lawyer learns rapidly that there is an uphill battle not only in terms of representing the client, but also in achieving or hoping to achieve the legitimacy of the defense function as a whole. There have been difficulties over the years with the court appreciating and understanding what that function means and accepting that function as an integral part of the process and granting the respect and legitimacy that's due to defense counsel. And I can mention the most famous example of all, which maybe some of you already know, but when the ICTY first opened, defense counsel was not allowed to eat in the cafeteria with the prosecution and the judges, nor were they allowed to use the library. They graduated up to being allowed to use the library with an escort. And now as the years have passed by, and particularly with the development of the Association of Defense Counsel at the ICTY, the defense there has gained a greater role in the processes at that tribunal that affect their daily existence. For example, having input into the rules of procedure and evidence, having input into disciplinary proceedings at the tribunal, which are conducted by an independent body, and similar things that really affect your day-to-day life. Being able to negotiate for a room that has enough computers in it for all the defense teams, that has a phone. I think we've worked our way up to 2 printers there now, and a couple of copiers. So it's been a long road, but it's a road that seems to be moving in the right direction, at least for the moment. And certainly, given a survey of the developments at other tribunals and at the ICC, there is increasingly, in fact, a recognition of the need to provide support and resources to the defense. Otherwise, the verdicts that are returned will have very little legitimacy, perhaps, in the eyes of those who watch the process. And, of course, that's consistent with the right of the accused to a fair trial and to counsel and to the time and facilities to prepare defense. So, for example, at the ICC, there is a defense office there now. There is not a defense office at the ICTY. There is not a defense office of the same caliber as the ICC at the ICTR. In Cambodia, there's a defense office. Sierra Leone has a defense office. And these offices have varying degrees of power and control or lack thereof in the particular circumstances that they are in. Today I'm going to talk about, in 15 minutes, I probably used 10 of them already, in 15 minutes about the defense office at one of the newest tribunals, which is the Special Tribunal for Lebanon. And this is perhaps represented, at least so far, one of the best examples of a defense office which is positioned at this point, I think, to do some excellent assistance and support for the defense community and the individuals who have cases there. On the other hand, it's also an office that has been given some particular burdensome tasks, which I'm going to talk about in a couple of minutes. One of which is to ensure the effective assistance of the counsel who will be representing accused there. And hence the name of my talk, which is the potential tensions between the defense and the defense office, because I think that this is an interesting experiment, and it will be interesting to see what happens as this office develops. And I suppose I should underline that the STL is new. The very first cases are starting there right now, and David Young, who will speak after me in a moment, is counsel in one, and will be talking about his case. But it is a brand new institution, and so no one is in a position as yet to say this will happen or that will happen. But certainly there's food for thought in the kinds of rules and regulations that have been put in place thus far for the defense office there. I see the office as representing a step forward in a whole number of areas. And the first and biggest is that it is an independent office and it is an organ of the tribunal itself. And this is not true at the ICTY and the other tribunals. The defense office is not one of the pillars of those institutions. It is not an organ of the tribunal. At the STL it is, and that is a step forward, hopefully, for the defense in gaining more participation and meaningful participation in the business of that tribunal day to day. The head of office there is considered to be, and these are matters that are in the articles of the statute of the tribunal as well as the rules of procedure and evidence there. The head of the office is considered to be on equal footing with the prosecution, words that are somewhat music to the ears of those of us who have been around for a while, in terms of rights of audience before the chamber and in inter-party negotiations. The office also has a very broad mandate. There's a whole list of things that this office will be responsible for. That includes the appointment of counsel. Now, this is something that's usually done in a registry. At the STL, this will be done in the defense office, negotiation of fees, and providing various kinds of support to counsel. They're charged with the responsibility of protecting the rights of the defense. And I find it to be an interesting charge because I'm not sure what that means. And I suppose as time goes by, some of that will become clearer. They are there to support and assist counsel and are charged with doing a number of things, some of which are done at other tribunals. Here the list is quite extensive and I think is a very positive step forward in terms of resources for the accused. For example, they will, for people on legal aid, provide legal research and memorandum and maintain a library of that for the lawyers who are there, and it's available as a resource for the lawyers who will be functioning at that tribunal. They will maintain a list of experts. It can sometimes be difficult for lawyers. For example, in my country, I'm used to, because of the nature of my system, doing a pretrial investigation, and I hear today that, of course, there are other systems where the lawyers who actually appear in court to try a case don't do that. And there are skills that need to be learned there by lawyers who don't come from a system where that's part of your job, as it is in the U.S. So in this sense, the defense office at the STL really does provide a valuable service by keeping a list of experts, a list of investigators, lists of individuals who can work as case managers and legal assistants. And believe me, when you come first brand new to a tribunal and you don't know anyone, and I remember first arriving at the ICTY on the Srebrenica case and not knowing anyone, and I didn't speak the language of my client and a series of other things. Having this kind of support is fundamental, a real step forward in terms, and I use that phrase a fair amount because I see it that way, in terms of fulfilling what the mandate of international criminal law should be, and that is equality of arms between the defense and the prosecution, meaning the ability to be on equal footing as much as possible in your ability to present your case. They are also charged with assisting self-represented accused by providing them with individuals to help them with their case. Now this is interesting because at the ICTY, self-represented accused have had to fight to get resources such as a legal assistant and others to assist them. They have so far won that fight to some extent. Still, there was a fight with certainly nothing in the statute that says that they're entitled to this kind of assistance. At the STL, the defense office has a mandate to provide it. They also provide facilities for defense teams on premises, and I was hearing with great jealousy from the story of David Young's facilities and what's been made available to the teams there at the STL, beyond the dreams of the ICTY Council, things like mobile phones and enough computers for everyone on your team. You almost want to cry with jealousy as you have visions of people at the ICTY fighting over computers mid-trial because they gave us 20 computers for 6 defense teams, and there just wasn't enough to go around. The office also maintains a list of qualified counsel, and in that sense, of course, is of assistance to the accused in providing them with information about who can go forward with their case. And of course, there's a big caveat there, which is there are no accused have yet been arrested at the STL, although there are cases pending, and it's questionable at this point, at least, whether the accused will come and appear before the tribunal in one fashion or another or not. And finally, the STL provides training for counsel. This is also historically a real problem in the criminal defense community because we all come from different backgrounds. When I went to the ICQY, I certainly could have used some training on the systems that were in use there. I'm sure it's true of other counsel who came. There was no training. You felt your way along day to day and did the best that you could. You made friends and you tried to get information from other counsel. There has been some training provided there, certainly not consistently. And the STL, I know, has provided significant training for counsel on their list. This is something that the ICC does as well on a yearly basis. So this particular gap in resources for the defense is something that apparently is being filled now, at least to the extent that these tribunals are able to do so. There are some problematic areas, what I consider to be problematic areas in the mandate that has been given to the STL Defense Office, and I think it'll just be interesting to see how this all plays out, because as I said earlier, we don't know yet what's going to happen there. One is that the Defense Office has the right of audience before the chamber, and I know has exercised the rights of audience, meaning they have gone in and argued certain legal issues before the chamber. To the extent that that occurs, and to the extent that the chambers are either influenced by those arguments or make decisions about perhaps future substantive law or procedural law, I find this to be an area of a potential tension and something that we all should think about very, very carefully. The Defense Office, after all, does not represent any individual accused. They're there to provide support and assistance to the defense. So lawyers coming in later who are presented with what could be a fait accompli about a particular legal issue or procedure, or perhaps at minimum a court whose mind has been influenced significantly before counsel arrives, may have difficulties with that. I always like to say if you put 3 lawyers in a room, you'll have 4 different opinions, and I mean that is, as we all know, the case. Not every lawyer sees the law the same, not every lawyer sees the case the same, not every lawyer would employ the same strategy. So this is a potential problematic area. Of course, the people who work in that office, in the defense office, are committed people who understand the defense function, and I am sure have thought through some of these issues. But it's something that I noticed immediately reading these rules, that it would make me, I think, somewhat uncomfortable if I felt that I was restricted by prior proceedings in some respects that were held in that context, in the broad context of the defense office representing an issue before the chamber in the interest of justice, which is one of the bases to do so there, before I had an opportunity, or any other counsel actually assigned to an accused, had an opportunity to address that issue. The office also has what I consider to be a burden, and I use that word on purpose, and this is perhaps the most problematic area, the burden to ensure, and this is by the statute as well as the rules of procedure and evidence, that the counsel that are appointed to cases are effective. This, I think, is something that we should all pay attention to and continue to pay attention to, because to me this is a crossing over of, oh God, I only have 3 minutes left. This is a crossing over of and blurring lines between what is a legal issue, that's the effective assistance of counsel, and what is a support for counsel issue coming from the defense office. I think that there's potentially a very large conflict if a defense office is charged with being a watchdog for the lawyers that it assigns to cases. And since I have some little time left, I'll zip through this now. One problem is that I see nowhere in the statute where the criteria is set for what constitutes effective assistance or not. That to me is a problem. Perhaps this will never come up in the tribunal, but it is certainly something that we need, I think, to be very careful about. The office is charged with, or at least it has the power and authority to ensure the assistance of counsel is effective by going through a process. One is that the office can invite counsel to come in to talk about their work with the office. Those conversations will remain confidential. That can be ratcheted up if the office has what's referred to as reasonable cause to believe that counsel may not be performing as counsel should, at which point the office may inspect and examine counsel's work. And when I read that, the hackles went up on the back of my neck as an experienced lawyer, saying it's one thing to have a consultation with an office, it's another to be put into what starts to feel very adversarial. You're examining my work. And again, 3 different lawyers can have 4 different opinions. Finally, if the office believes that counsel is in some way deficient, they are free to go to the trial chamber and make representations to the trial chamber that counsel should be removed from a case. And that is perhaps the largest conflict of all, because again, the standards are potentially unclear as to when that occurs. It appears to be a conflict between the defense office role to support defense lawyers and essentially the contrary role of being a watchdog over those lawyers. It potentially directly interferes with the attorney-client relationship. Some clients like their lawyers well enough, they don't care if you're incompetent, they want you. I'm sure that in some respects that should this ever occur at this tribunal, that clients will be consulted. Still, it is, to my mind, something that really mixes the roles in a way that's potentially not a good thing for the development of a defense function and how that function is seen and the legitimacy that is given in the international community if this kind of process goes on. And I'm sure I've run out of time now. So I'll conclude as quickly as I can. This is a big subject for a small period of time. I think that the STL office is actually an innovative an interesting experiment that will be of huge benefit to the people who have cases there. What I hope, though, is that the experiment will be carried out in its best of all possible ways, and that in the struggle that we all have in gaining legitimacy as defense lawyers in this complex world of the practice of international criminal law, that we don't, let's say, shoot ourselves in the foot by building in any respect, any area of lack of trust and full confidence before we all get our collective feet firmly established on the ground. I'm sure I'm over my time now. All right. Well, thank you.